All right, so we continue our discussion on the freedom of expression under the First Amendment and the topic of unprotected or less protected speech. And just as a reminder, we've talked about several areas of speech that the court over time has considered unprotected or less protected. We've talked about the incitement of illegal activity. We've talked about speech that provokes, also known as fighting words or hostile speech, or speaks that provokes a hostile type of response from an audience. We've talked about racist speech or hate speech. And so on this video, we will go in depth on the topic of sexually oriented speech. So it's important to know that the government regulation of sexually oriented speech is a major topic under the First Amendment, right? The Supreme Court has held that obscenity is a category of speech that is unprotected under the First Amendment. And over time, the court has struggled with ways or how to define obscenity. As a result of the cases that have come before the court, there are really several categories of sexually oriented speech that the court has considered over time. These categories obviously include obscenity. We'll talk a little bit about what obscenity means, what its protections are or are not under the First Amendment. The court has been presented cases dealing with child pornography. They've also been presented with cases that where speech is considered protected, but it's low value sexual speech, right? And so we'll talk about what that means as well. And then finally, the court has considered whether profanity and indecent speech warrant constitutional protection. And then we'll end this discussion today with the potential, and although this isn't directly related to sexually oriented speech, but we will talk briefly about the potential for a new category for violent speech, which is tangentially related to profane speech, profanity, or indecent speech, right? So let's jump into the overall topic of obscenity. It's important to know that the court has indicated that government has more latitude to regulate sexually oriented speech, even if that speech is not obscenity or child pornography that are unprotected by the First Amendment. So I've kind of already unveiled, if you will, or revealed that obscenity and child pornography are two types of sexually oriented speech that are not protected by the First Amendment. And so a discussion of obscenity in a constitutional context necessarily asks several questions. The first question is, should obscenity be protected under the First Amendment? And so we'll talk a little bit about that as we get into what obscenity means and how the court has come to consider it over time. A second question is, if obscenity should be protected under the First Amendment, then how should it be defined, right? We'll talk about an important case that the court has used over time, over several decades now, to define speech. And then finally, we will look at what actions can the government take to regulate obscenity. All right, so let's get into the first question of should obscenity be protected under the First Amendment? Several major arguments have been advanced over time as to why obscenity falls outside of the scope of First Amendment protections. First, the court has determined that obscenity is really without any social value, right? It has no social value, and as a result, it should be unprotected by the First Amendment. The Supreme Court accepted this argument regarding obscenity in the case of Roth versus the United States, where the court held that obscenity is a category of speech that's unprotected by the First Amendment. So in Roth, the constitutionality of a criminal obscenity statute was at issue. And the relevant language of the statute prohibits the mailing of every obscene, lewd, lascivious, or filthy book, pamphlet, picture, or what have you, that's of an indecent character, right? So that was the language of the statute that prohibited this obscenity. And so the court in Roth considered the question of whether this statute violated the First Amendment. And the court held that obscenity is outside the protection intended for speech and press, in that obscenity has no redeeming social importance. The court noted that sex and obscenity are not the same. Obscene material, the court commented, is material which deals with sex in a manner appealing to the prurient interest. And that's going to be a very important word there as we continue to dive deeper into how the court has defined obscenity over time. And so again, obscene material is material which deals with sex in a manner appealing to the prurient interest. In contrast, artistic, scientific, and literary portrayals are protected under the First Amendment. And so if you have an artistic portrayal of sex, or a scientific or literary portrayal of sex, then those are protected by the First Amendment. Important in Roth was the dissent. And the dissent noted the language of this particular statute that was at issue sought to criminalize an individual's thoughts. And the dissent was of the opinion that to allow the state to punish mere speech or publication that has an undesirable impact on thoughts, but is not shown to be a part of any unlawful action, is directly in contravention of the First Amendment. The dissenting justices use the language, it drastically curtails the First Amendment and the protections that it provides, right? Nevertheless, Roth is a very, very important case in terms of the foundation, right? And the initial consideration that the court determined that obscenity is a category of speech that is not protected under the First Amendment. Now, after Roth, there were other arguments that the court considered in how obscenity was restricted, whether it was by local ordinances, via statutes in states, or any type of legislative action. Other reasons why obscenity over time has been deemed to be unprotected under the First Amendment is that because it causes antisocial behavior. Now, in this case, the claim is that obscenity increases the risk of violence and physical aggression against women. There's also an argument that it undermines social values. And the court considered both of these arguments in the case of Paris Adult Theater versus Slayton. In Slayton, you see the court reaffirms that obscenity is not protected under the First Amendment. And so in Slayton, an adult theater in the city of Atlanta was the subject of a civil complaint by the state district attorney that alleged that they were showing two obscene films that depicted sexual conduct that had been characterized by the Georgia Supreme Court as hardcore pornography that left little to the imagination, right? In Slayton, the court held that there are legitimate state interests at stake in stemming the tide of commercialized obscenity, including the interests of the public in the quality of life and the total community environment, the tone of commerce in city centers, and possibly the public's safety itself. The court noted that in its holding, the holding did not apply to thoughts or speech in that regard, but rather to the depiction and description of specifically defined sexual conduct that states may regulate without limits designed to prevent infringements on First Amendment rights. The court noted that the states have a legitimate interest, and when you think about it, remember, states have the obligation to protect the health, safety, and welfare of their citizens, right? And so the court noted that the states have a legitimate interest in regulating commerce in obscene material and in regulating exhibition of obscene material in places of public accommodation, including the so-called adult theaters from which minors were excluded. So you see here our initial considerations, right, of how the court considered obscenity, right, and why it was not protected under the First Amendment. But an important question as it relates to obscenity is, how should obscenity even be defined, right? And so we saw a snapshot, if you will, or smidgen, or an attempt, let's call it, by the court to define obscenity in the Roth case, which again, Roth was a case that occurred in the 1950s, right? The mid to late 1950s. It wasn't until the 1970s that the court really latched on to defining what obscenity is, right? So remember, in Roth, the court initially said that obscenity is that which appeals to the prurient interest. Now, prurient is defined as that which excites lustful or lascivious thoughts. This term is still a part of the current test that was outlined in the seminal case of Miller versus California. This was a 1973 case that is the key case for the test of obscenity. So in Miller, this case involved a mass mailing that was sent to many unsuspecting individuals, meaning without their request or their consent, by an individual who was advertising illustrated books that contain adult material, right? He was convicted under California law of knowingly distributing obscene matter. And so in Miller, the court articulated the test to determine and define the permissible scope of state regulations with respect to works that depict or describe sexual conduct. And so in Miller, the court said the conduct prescribed must be specifically defined by the applicable state law, as written or as authoritatively construed. The state regulation must be limited to works which, taken as a whole, appeal to the prurient interest in sex, which portrays rather sexual conduct in a patently offensive way, and which, taken as a whole, does not have serious literary, artistic, political, or scientific value. So let's unpack that a little bit, right? So we already know from Roth that the court considered obscenity that which appeals to the prurient interest, right? And so we see that as the first part of the test for obscenity that the court outlines in the Miller case. However, there are a couple other pieces of the test that the court articulates under Miller. And so, in addition to appealing to the prurient interest in sex, the material must portray sexual conduct in a patently offensive way, right? And so, let's walk down it so we can see it here. So the first part of the test is whether the average person, right, in applying contemporary community standards, meaning standards which apply to the local community where the regulation is being challenged, right? And we understand that these regulations may vary from one community to another, but whether the average person, when applying contemporary community standards, would find that the work taken as a whole appeals to the prurient interest, right? So we have that the first part of the test defined. The second part is whether the work depicts or describes in a patently offensive way sexual conduct that's specifically defined as being prescribed or prohibited under the regulation that's being challenged. And then finally, whether the work taken as a whole lacks any serious literary, artistic, political, or scientific value. And that third part is very important. Why? Because um, in order to have any sort of protection under the First Amendment, the work must have some sort of literary, artistic, political, or scientific value, right? If it has value in that regard and meets those other two prongs, then the work can still be protected under the First Amendment. However, if it lacks any artistic or literary or political or scientific value and meets those other two prongs as well, then it will be deemed obscene and will not be protected under the First Amendment. So the Miller test for obscenity still is good law today, and it's very important to understand and to commit to memory each prong of the Miller test. So if you are confronted with a question regarding obscenity and whether material or speech could be deemed obscene, that you know what test to apply and what elements of the test must be met in order for the regulation to be deemed constitutional, right? So we have now gotten into defining what obscenity is, right? We've talked about fundamentally that obscenity generally is unprotected under the First Amendment. We now have an established method of how obscenity will be defined, and we know that the only type of work that, if it's considered obscene, that could be protected under the First Amendment is that work that has serious literary, artistic, or scientific value. But what actions can the government take in regulating obscenity? And so over time, the court has considered this question in several cases that's been or that's come before it or that's been presented to the court. The first instance is that dealing with child pornography. And the key case for obscenity as it relates to or sexually oriented speech as it relates to child pornography is the case of New York versus Ferber. In Ferber, the issue was whether a New York criminal law that prohibited persons from knowingly promoting sexual performances by children under the age of 16 by distributing material that depicted performances by kids under the age of 16 violated the First Amendment's free speech guarantees. And in Ferber, the court held that no, the statute did not violate the Constitution. The court noted that states are entitled to a greater leeway in regulation of pornographic depictions of children for several reasons. The court noted that one, states' interest in safeguarding the physical and psychological well-being of a minor is compelling, right? And using that language, you know that they're talking about narrowly tailored regulations that must achieve a compelling interest, right? And so the interest of the state to safeguard children from physical and psychological abuse is certainly compelling. The court went on to note that the prevention of sexual exploitation and abuse of children constitutes a government objective of surpassing importance. Now, in evaluating this New York law, the court considered the Miller test because Ferber took place roughly 9 or 10 years after Miller. Ferber was decided by the court in 1982. And the court noted that the Miller test alone does not address the concerns associated with child exploitation because a work may have some serious artistic, literary, political, or social value and still involve child exploitation. So remember, we talked about if the work has a serious artistic, literary, political value, that it could be protected under the First Amendment. But in Ferber, the court says, look, no, even if it has, or even if the work meets these definitions and still involves child exploitation, then it's not going to be protected under the First Amendment. The court also noted that there is little or de minimis value in permitting the live performances and photographic reproductions of children engaged in lewd sexual conduct, right? And so the court was clear that the government has a greater leeway, if you will, to regulate or control obscenity, certainly when it comes to depictions of children for the reasons that were outlined in the Ferber case. The court over time has also held that the government cannot prohibit or punish the private possession of obscene material, although it may outlaw the private possession of child pornography. And so think about that latter piece in the context of Ferber. But when it comes to punishing the private possession of obscene material, the court has held that the government cannot prohibit or institute or establish regulations that prohibit or punish this private possession of obscene material. And the key case for that consideration is the case of Stanley versus Georgia. And so in Stanley, while searching Stanley's home pursuant to a search warrant for evidence of bookmarking activities, federal and state agents found videos and films that were deemed to be obscene. And Mr. Stanley was charged and convicted under a Georgia law of knowingly possessing obscene matter. And so the court considered whether the law that punished the mere possession of obscene material violated the First Amendment. And the court held that, yes, the mere private possession of obscene material cannot constitutionally be made a crime. The court noted that a person in his or her home has the right to choose what to read or watch. And if the First Amendment means anything, it means that a state has no business telling a man sitting in his own home what books he may read or what films he may watch. And so the court was clear that punishing or prescribing private possession of obscene material was in fact unconstitutional. But it's important to note again that this freedom to watch or read obscenity does not include child pornography. And so we talked a little bit about Ferber, but that specific provision that the freedom to watch or read obscene material that encaptures child pornography was laid out in the case of Osborne versus Ohio. So we know how the court now approaches child pornography and regulations that attempt to control child pornography, as well as the private possession of obscene material that is not child pornography, right? So what about speech that can be or sexually oriented speech that could be protected but is considered low value by the court? And so some speech is what the court has over time come to refer to as low value speech, meaning the speech is sexually explicit, but it's not considered obscenity. And the court has determined that this sort of speech may not be banned, but the government can regulate it. And so traditionally, the court has used little more than rational basis review for this type of speech, right? But underlying issues remain as to whether there should be such a category how it should be defined, and what level of scrutiny should be used when you're considering this type of speech. And so, two areas where the court has considered protected but low value speech um, comes into play when you see regulations or local governments or state governments use zoning regulations that regulate the location of sexually oriented expression, or the regulation pertains to indecent speech or what we may call profanity, right? And so, as it relates to first, this use of zoning, right, as a regulation for where sexually oriented expression can occur, the first case to really consider that question was the case of Young versus American Mini Theaters. And so, this was a case that that the court considered in 1976, and in Young, the city of Detroit adopted an ordinance that limited the number of adult bookstores or movie theaters that could be in any block or within any type of parameters or a certain area, right? And so the statute was quite specific in defining what an adult bookstore was or what a movie theater was, and the limits, if you will, of where they could be located. And so the court in Young upheld this particular ordinance in the city of Detroit, and the court made 3 points in upholding the law in its ruling. First, the court said that the regulation was not viewpoint based. That's important to consider. Remember, because if a city or a governmental entity or the state, right, regulates by viewpoint, then that usually has to meet a threshold of what? Strict scrutiny, right? So in this case, though, the court said that the regulation was not viewpoint based. The court says that the core of the First Amendment is viewpoint discrimination. This wasn't an instance where the regulation of speech was being based on the view that was expressed. The second point that the court noted in Young was that sexually oriented expression is less protected by the First Amendment than political speech, and as a result, it's more subject to regulation. So, if you remember back to when we initially began our discussion on freedom of expression, one of the highest levels of speech that is protected is political speech, right? And so in this case, the court said, look, sexually oriented expression doesn't rise to the level of warranting the protection like political speech does. And as a result, it's subject to more regulation. And then finally, the court noted that the city has an important interest in preserving the quality of its neighborhoods. And as a result, the court held that the city's interest in the present and future character of its neighborhoods adequately support its classification of these movie theaters and adult bookstores, right? However, interestingly, in this case, the dissent considers this ordinance as a prior restraint, right? They consider these zoning requirements as a prior restraint. And you know that in our earlier discussions regarding prior restraints, that the court has frowned upon prior restraints, or typically has held prior restraints to a higher level of review than obscenity or what we have now come to call sexually oriented speech, right? Another example of the court's treatment of sexually oriented speech as being of low value is its willingness to allow the government to regulate and or prohibit nude dancing. And so we see this prohibition of nude dancing in one of the minor cases in the text that wasn't captured as a major case, but it's important nonetheless. And that was the case of Barnes versus Glenn Theater. In Barnes, the court held that the government may ban nude dancing laws that prohibit nudity. And in this particular case, an Indiana statute prohibited public nudity that was used. Well, let me say it differently. In this case, an Indiana statute prohibiting public nudity was used to require female exotic dancers to wear pasties or G-string when they dance, right? And so even though nude dancing is conduct, the court noted that has an expressive component, the government may nonetheless regulate it when it has an important or substantial interest unrelated to the suppression of this expression, right? Such as protecting societal order and morality, right? And so the court noted a couple of important points in Barnes that it suggested justified government regulation in this case. And so the court noted that a government regulation is sufficiently justified if it is within the constitutional power of the government, if it furthers an important or substantial government interest, if that government interest is not related to the suppression of free expression, and if the incidental restriction on alleged First Amendment freedoms is no greater than is essential to the furtherance of that interest, right? And so this approach that the court took to evaluating the regulation of nude dancing with these four prongs under Barnes was important. It was an important approach that the court used. And subsequently to Barnes, the court reaffirmed its holding in the case of the city of Erie versus Paps A&M, right? In a 2000 case where an ordinance in the city of Erie, Pennsylvania, that banned public nudity was challenged by an owner of a nude dancing establishment who sought to enjoin enforcement of the ordinance. And so in Erie, the court emphasized that the city was justified in prohibiting nude dancing so as to stop the undesirable secondary effects such as crime that were or that could be associated with the activity. And that's important because that's what the court relied on that position, but of course it was challenged by the dissent. And we'll talk about that in a minute. The court noted that the state's interest in combating the negative secondary effects associated with such establishments was unrelated to the suppression of the expression. However, the dissent noted that while the court relies on the desire of the state to stop undesirable secondary effects, the state has presented no proof that nude dancing increases crimes or causes undesirable secondary effects. The dissent really saw no real difference in complete nude dancing or the use of pastries and G-strings. And so the court, or the dissent rather, took issue with the reliance of the court on these or on the state's articulated interest to stop the undesirable secondary effects when the state, in fact, had not presented any evidence in support of this position. So we've walked down now the category of obscenity as unprotected and less protected speech, right? We talked about obscenity. We've talked about sexually oriented speech that the court has considered protected, but has low value or is low value sexual speech. And so, again, tangentially related to that is the category of profanity and indecent speech, right? And so in this particular category, it's important to note that generally it's protected by the First Amendment, but there are notable exceptions. Although profanity and indecent speech are not obscene, the government often has tried to punish them nonetheless. And the Supreme Court, again, has generally held that such language is generally protected by the First Amendment. But again, there are notable exceptions. The court has expressly adopted what it calls a medium by medium approach, right? When it considers indecent speech as it relates to how that speech is communicated, right? And when you think of medium by medium, they're talking about the channel that the speech is communicated through, right? So think maybe by television or by radio or by internet, right? Those are all mediums, right? And so in evaluating profanity and indecent speech, the court has adopted again this medium by medium approach. And so the first instance that the court considers this category of profanity and indecent speech was in the case of Cohen versus California. This was a 1971 case where the petitioner, Mr. Cohen, was arrested, convicted, and sentenced as a result of wearing a jacket bearing the words "F the draft" in protest of the draft and the Vietnam War. Mr. Cohen wore this jacket in public. The public place was the LA County Courthouse. He didn't do anything. He didn't threaten anyone with any kind of violent behavior. He didn't make any loud or unusual noises. Mr. Cohen never uttered a word. He just wore this jacket in the LA County Courthouse. And so the court considered whether the state of California could excise Mr. Cohen's conduct as offensive just because it used a particularly scurrilous epithet in describing or in articulating F the draft, right? And so the court noted that absent a more particularized and compelling reason for its actions, the state may not make the simple public display of a single four-letter word a criminal offense, right? And do so in compliance with the First Amendment and the 14th Amendment, right? The court noted that the state's action, or the state of California's actions in this case, were not one or the type that fell within one of those relatively few categories of instances which the government has the power to prohibit speech that is unprotected. The court noted that in considering Mr. Cohen's speech, right, it wasn't obscenity in that it did not conjure up any sort of erotic images, right? The language was not or could not be considered fighting words because it did not pose a true threat of violence to the hearer. The court also noted that the audience was not captive in this case. The audience could just simply walk away. And so the court felt like that they could not, or that there could not be this stifling of speech because of this hypersensitivity or squeamishness of individuals who may have been sensitive to the use of this word, right? The court noted that one man's vulgarity is another man's lyric, right? And words have both emotive and cognitive force. And so ultimately the court struck down this particular law as noting that it was not constitutional in the case of Cohen. And so again, think about it like this. This particular medium, right, that was used in Cohen was a situation where Mr. Cohen was just in a public place, right, at a courthouse, right? And so the way that this offensive or profane or indecent speech was communicated was through an article of clothing as Mr. Cohen walked around the courthouse in protest of the Vietnam War. But let's think about speech in another type of environment or through another medium, right? And that's speech via various broadcasts, right? The court has viewed each medium differently, right? So whether it's TV or radio or the internet, the court has viewed each medium differently. And one of the key cases regarding profanity and indecent speech is the case of FCC, or the Federal Communications Commission, versus Pacifica Foundation. And in this case, the court upheld the prohibition of indecent speech over the radio, right? And so in Pacifica, an interesting case that dealt with the use of profanity by a well-known comedian by the name of George Carlin, right? And so Pacifica dealt with a case that at about 2 o'clock on a Tuesday afternoon, a New York radio station broadcasted this comedy monologue by George Carlin entitled "Filthy Words," right? And so, needless to say, the language of the monologue contained words that were not appropriate to be broadcast over the public airways, right? And so a man who claimed he and his young son heard the broadcast in the car filed a complaint with the FCC against the broadcast company. And so the FCC determined that the broadcast was in fact sanctionable, but put the complaint in Pacifica's license file in the event another or any other complaints came in regarding this particular broadcast. And so in response, Pacifica alleged that the statute was overbroad and that because the monologue was not obscene, it was protected under the First Amendment. And so the court was tasked with considering the issue of in what situations and under what circumstances may the government restrict the public broadcast of indecent but not obscene language in a way that was consistent with the First Amendment. And so the court issued a very narrow holding that was only limited to this type of situation, right? The court noted that while it might be the right thing at the wrong time, or if it's a type of speech that could be considered the right thing at the wrong time, then the government may prohibit it, right? And so that was another way of the court saying that this was speech that was really of no redeeming value, right? Or was, in other words, low value speech. The constitutional protection, the court noted, of certain low value language that is patently offensive, whether it's using sexual terms or other profane terms, need not be the same in every context, right? The level of protection, the court noted, varies with the circumstances. And so the court essentially stated that each medium of expression must be taken on its own merit because each medium presents, different First Amendment problems. Broadcasting receives the most limited First Amendment protection, right? Because broadcasting has a uniquely pervasive presence that confronts not just the public, but also persons in places that may be protected as private, i.e. their homes, right? Broadcasting is also uniquely accessible to children, which was what essentially occurred in this case. You had a child who heard this profanity over the airways while riding in the car with his father. And so, broadcasting, the court noted, is also uniquely accessible to children, even those who may be too young to read. And so as a result, this type of medium gets the most limited protection under the First Amendment, and the court, the commission, the FCC, it's finding that this particular broadcast was sanctionable, was upheld in this instance by the court. What about in instances or circumstances where the internet is implicated, or you're dealing with the internet? The Supreme Court's first major decision concerning the internet involved the same distinction between obscene and indecent speech in a federal law regulating the internet. And so the court declared unconstitutional the regulation of indecent speech over the internet. And this particular issue came up in the case of Reno versus the ACLU in 1997. In Reno, at issue was the constitutionality of two statutory provisions that had been enacted to protect minors from indecent and patently offensive communications on the internet. And so the Communications Decency Act of 1996 made it criminal to send or display patently offensive materials. Well, do you think that would be upheld in 2023? Probably not. And so the issue was whether the Communications Decency Act violated the First Amendment guarantees of freedom of expression. And the court held that this particular statute abridged the freedom of speech that was protected by the First Amendment. The court pointed out that the statute was different from the FCC regulations and sanctions that had been issued in the Pacifica matter, because the FCC targeted when and not whether the speech could occur. When meaning the time that the speech could occur was limited. The FCC limited the time that such information could be broadcasted and over what medium. The court said that that wasn't the case in Reno. Also, the court noted that no one was a captive, unwilling audience in this case, right? There was no captive, unwilling audience because accessing websites is a deliberate process. You have to desire to go onto the internet. And so you weren't being held hostage or you weren't unable to avoid it, right? Well, that's arguable, right? Because you could argue, well, if you're in the car, and certainly even if you look at the Pacifica case, if you're in the car, or this father certainly could have just changed the channel, right? He could have changed the station. The kid didn't have to sit and listen to the profane or the profanity that took place from the comedic monologue. Nevertheless, though, in this particular case, in identifying this distinction between the medium of the internet and the medium of broadcast radio, the court also noted that the Communications Decency Act was not zoning as the government had argued in this case, because restrictions apply broadly to all content at all times. The CDA as a statute targeted speech, the court felt, for its content, which cannot be said, obviously, to be a time, place, and manner type of restriction, which was what the court essentially held in the Pacifica matter. And so for all of these reasons, this is why the court determined that this statute, in this case, abridged the freedom of speech protected by the First Amendment and should be struck down. The court also noted that there was a vagueness problem with the statute, right? Because since the law was content-based, one had to guess on what is or what isn't permissible. And as a result, this uncertainty or this requirement to guess what's allowed and what's not allowed could have a chilling effect on free speech. And so we see these distinct differences between the medium or communicating profanity or indecent speech in person, right? Like the example in Cohen, versus being broadcast over the television or the radio, like in the Pacifica case. And yet another distinction, if the medium chosen to broadcast the profanity is the internet, right? And so note the distinctions or the differences that the court employed in these cases, right? So finally, our final topic for this video session of unprotected and less protected speech is the consideration of whether there are or may be this exception for violent speech, right? And so, in two fairly recent cases within the past 15 years or so, the court has declined to extend or add violent speech as a category of unprotected speech. And so, specifically, in 2010, in the case of United States versus Stevens, the court determined that a federal law criminalizing the commercial creation, sale, or possession of certain depictions of animal cruelty was substantially overbroad and therefore invalid under the First Amendment. And so in this case, Stevens dealt with I guess, if you want to call it a phenomenon at the time, but this gross conduct, if you will, of animal cruelty that was called crush videos, where animals were unnecessarily just abused, right, and placed in cruel situations. The court noted that in Stevens, these particular laws that criminalized the creation of these videos was overbroad, and as a result, they were invalid under the First Amendment, right? Because the First Amendment protected videos that fell within the definition given by the statute. And so, for example, if the statute had been upheld, right? If a hunter decided to video himself hunting and killing a deer, then that type of a video would have violated this statute, right? And so, of course, the court felt like, or rather determined, if you will, that these sort of videos, because they were substantially overbroad, did not fall within the protection of the First Amendment. In addition to the Stevens case, there was also the Brown case, Brown versus the Entertainment Merchants Association. And in Brown, in a 7-2 ruling, the court struck down a California law that made it a crime to sell or rent violent video games to minors under the age of 18 without a parent's consent. And so Justice Scalia wrote the majority opinion in Brown, and his opinion stressed that violent speech is protected by the First Amendment, and thus the California law was a content-based regulation, and that as a result must meet strict scrutiny. The court noted, and Justice Scalia noted in the language of his ruling, that the most basic principle that government lacks the power to restrict expression because of its message, ideas, subject matter, or content is subject to a few limited exceptions for historically unprotected speech, right? Such as obscenity, incitement, and fighting words, right? Which we've already established. But Scalia went on to note that a legislature cannot create new categories of unprotected speech simply by weighing the value of a particular category against its social cost and then punishing it if it fails the test. And so you do not have this exception of a new category for unprotected or less protected speech that could be considered violent, right? These two cases have shown that this type of speech, although it potentially offensive to some, nevertheless, is still protected under the First Amendment. So that wraps up our discussion on these particular categories. Again, we've talked about sexually oriented speech that includes obscenity, right? That also includes sexually oriented speech that could be protected, but the court has deemed to be of low value. And we've talked about profanity or indecent speech. And then finally, we concluded with this discussion of the court's refusal to carve out or create a new category of unprotected or less protected speech um, for violent speech, right? And instead has chosen to allow violent speech to be speech that is protected under the First Amendment. So make note of these key cases on these categories of unprotected and less protected speech. Make sure you update your outlines, and we will see you on the next video.